Welcome to everyone listening. If you are listening after this is recorded, my name is Joshua Eveleigh. I am a managing associate here at Primerio International, and I'm joined today by Carole Bamu and Calistar Dzenga from the Competition and Tariff Commission. Just briefly about Primerio, we are a boutique competition law firm based in South Africa with regional hubs and strategic partners allocated along or across Africa, and Zimbabwe being one of them. This is probably around the 5th or 6th iteration of this podcast series that we're now lucky to have with Calistar. Previously, we've done Zambia, Camesa, Mauritius, Nigeria. So it's a real honor to be able to extend the podcast and to extend the knowledge base of African antitrust to a broader community. So I've done a brief intro to Primerio, what we do. I'd now like to pass on to Carole, if you could just do a brief intro to yourself and then to Calistar.
Thank you, Joshua. So by way of introduction, my name is Carole Bamu. I'm from Bamu Attorneys here in Harare, Zimbabwe. My main areas of practice are corporate commercial, and I guess that's where the interest with the mergers and acquisitions come in. Mainly in the financial side, that's where I deal mostly. So we do acquisition finance, asset financing, brokering of shares, sale, private sale, public sales. And this is my 10th year in practice. We are a partner firm for the local partnership with Primerio International, and we handle all of their Zimbabwe regulated or Zimbabwe specific work. And we basically assist clients handhold with the regulatory and compliance aspects of their Zimbabwean needs. So that's where I come in. I work very well with Joshua here, mostly in the mergers space. Thank you very much.
Great. And Calistar, maybe a bit about yourself and your role at the CTC.
Thank you very much, Josh. So greetings, everyone. Calistar Dzenga is my name, from the Competition and Tariff Commission in Zimbabwe, which is a competition regulatory authority responsible for examination of all major transactions in Zimbabwe, among other mandate areas. I am the head of majors in the Competition and Tariff Commission, having been with the Commission for 17 years now. I've gained much experience in major regulation. Of course, I've had investigations also in the restrictive practices, but as of now, I'm specializing in major regulation. Thank you.
Yeah, that's great. And I think with you being head of mergers, you should be aptly able to answer all of the questions today. So I think on that note, Carole's going to do our first lot of questions really into the premise of merger control in Zimbabwe. So the ins and outs and the foundational aspects of merger control. So Carole, you can take it away.
Sure. Thank you very much, Josh. Calistar, so our first theme pertains to the general overview of merger control, of the merger control regime in Zimbabwe. And the first question is, how does the Commission determine whether a merger is notifiable? Are there any thresholds?
I think you're on mute, Calistar.
Oh, sorry, my mic was off. Okay. So thank you very much, Carole, for that question. So we regulate mergers using the Competition Act, Chapter 1428, and merger regulation is specifically provided for in Section 34 of the Act and as defined in Section 2 of the Competition Act. And so for a transaction to be notifiable to the Commission, firstly, it should fit within the definition of the term merger as provided for in Section 2 of the Act, and notifiability of the merger is then determined by the level of combined assets or combined revenue of the merging parties in Zimbabwe, and which is currently pegged at a minimum of 1.2 US dollars or its equivalents in the local currency. And so it therefore implies that not all mergers are notifiable to the Commission, but only those which meet the 1.2 million USD threshold.
I think sorry, Carole, as a follow-up question to that, as I suppose a Pan-African competition law firm, a lot of the questions we get regarding the Zimbabwe thresholds is whether, if in a situation, for example, you've got a company in Germany and then a company in Japan, for example, and then the company in Japan maybe sold a few products into Zimbabwe during the last financial year. And because of those few sales, they crossed that $1.2 million threshold. Would the Competition and Tariff Commission still regard that as a notifiable merger, despite the fact that both companies are sitting outside of Zimbabwe, and the only, I suppose, link or nexus to Zimbabwe are those sales or those exports into Zimbabwe?
Okay, thank you very much, Josh. So Section 3 of the Competition Act stipulates that the Act applies to all economic activities having an effect in the Republic of Zimbabwe. And regarding your question, it therefore implies that those companies, even though they are domiciled outside of Zimbabwe, but in as much as they are selling to the Zimbabwean market, it implies that such a transaction has an effect in the Zimbabwean market. And so if the turnover that they derive in the Zimbabwean market is at least 1.2 million US dollars combined, then that transaction is notifiable to the Commission. And we have held quite a number of transactions which are foreign to foreign transactions, but have been notified to the Commission, and we have assessed them and given them decisions.
Yeah, that's very useful.
What is the process of reviewing a merger in Zimbabwe? Are there staging, specific timelines that various stakeholders should be aware of?
Okay, thank you, Carole. So in terms of the specific processes for reviewing major transactions, I would say that the first process is the major notification itself, where the parties should complete the major notification form, which is available on our website. And after they've notified us, they filled the form, they then pay the notification fees, which is currently calculated as 0.5% of the combined turnover or assets of the merging parties in Zimbabwe, and we take the higher value. But however, there are caps to that. If we calculate the fee and it's above 40,000 US dollars, we then charge a maximum of 40,000 and a minimum of 10,000. And after the parties are fully notified, that is, are filling in the form and paying their fees, we then have an engagement with the parties just for us to be able to understand the transaction, to make sure that what is written on the form is also what our understanding is of the transaction. And the purpose also of that process is for us to identify to them any information gaps for them to be able to go and provide additional information. And after the parties have submitted additional information, we then consider the transaction to have been fully notified, and we then start counting our days, and the major examination process starts. After that process, the next stage is desk research by the case handler, where they also, after that, they also do stakeholder consultations, where we consult whether that be their customers, competitors, suppliers of the merging parties, sector regulators, and other government bodies, for us to determine the effect of the transaction in the market, and also for us to have an appreciation of the relevant market where the parties are operating for us to be able to make an informed decision. After that, we then do our report writing, consolidating all the information that we have gotten from the merging parties through their media notification form, the engagement with them, and also the information that we have gotten from the market. After that, we then present our major examination report to the relevant committees, internal committees within the commission, and then ultimately to the board. You also note that we classify our transactions into two. We classify our majors into small majors, those which we do not think are going to substantially lessen competition, and the other one is big majors, those which we think may substantially lessen competition or may need to be approved with conditions, or where parties have to pay penalties if they have violated the provisions of the Competition Act by proceeding to consummate the measure without the approval of the Commission. And also, it's also important for you to know that all decisions on measures are made by the board. So our setup is that we do not have a tribunal. We have a board which oversees the functioning of the commission and which makes decisions of the commission. And the board operates through subcommittees. Like for small measures, we submit our small measures to the technical committee, which then makes a final decision on that transaction. So for those transactions which are approved with no conditions, they are determined at the technical committee level. But for those transactions which are classified as big, they pass through both the technical committee and the full board. So for big transactions, then the full board, in terms of the Competition Act 315, the board then makes an intended decision so that they give parties the opportunity to make their representations to the commission for the rule of natural justice, I assume. And then after the parties have made their representations, the case then goes through the process again. From us, the directorate, we make the analysis of the representations, we make our recommendations to the final decision making by the board, and we then notify the parties of the commission's decision. And if the parties are not satisfied or are aggrieved by the decision of the commission, they can appeal to the administrative court. So that is the process, the major review process in Zimbabwe.
That's very useful, and I didn't know all of that. So thanks for sharing that level of detail. Maybe just two follow-up questions from my side. Okay. So you said there's a distinguishment between small mergers and then big mergers. Yes. Are they subject to different review periods, or, for example, is a big merger capped at 60 days and then a small merger capped at 30 days, or is it a bit more informal than that?
Oh yes, that's quite an important question. So for small mergers, normally a decision is made within 30 days, though there's no specific statute to that. But administratively, we've just ensure that small mergers are decided on within 30 days, so that we do not necessarily delay businesses or frustrate business. And for big transactions, administratively again, they are decided on within 90 days. However, in cases where we feel that the transactions are too complex, we then notify the merging parties of an extension of the 90-day period to around 120-day period, where the parties would have gotten their decision. And this also applies to post-merger notifications, because those ones involve a lot of investigations, because it's a post-merger really, and the level of cooperation from the parties may be very low compared to pre-merger notifications. So it will take quite some time compared to pre-merger notifications.
Great, thank you. Then I suppose my second follow-up question is, in a lot of competition regulators across the continent, you see that their executive committees or their board only sit every 2 or 3 months, and that can obviously delay getting your approval, which in the grander scheme of things, when you've got a global deal, can quite a bit of uncertainty for merging parties. With the CTC, how often does the board sit then to finally approve, for example, the big mergers, and how often does the technical committee sit to then approve the small mergers?
Oh, okay. So for the technical committee, they've got the board calendar days, where they meet quarterly, which is 4 times a year. But whenever we've got transactions that are ready to be considered, they convene. We request them to convene a special technical committee for them to deliberate and to decide on the transaction, so that it doesn't really have to wait for the board calendar days. The same applies again even for the full board. Whenever we have cases that we feel the agent needing board attention, they convene a special board meeting while it's waiting for the board calendar days.
Okay, it's good to know. Carole?
Let me just open my notepad. Josh's follow-up questions just got me off the train a little bit. But Calistar, you spoke of lessening the competition. So how does the CTC assess whether a merger substantially lessens competition? How do you do that?
Okay. Yeah, this is the detailed merger assessment that we do to determine whether the transaction is going to substantially lessen competition or result in a creation of a monopoly situation contrary to public interest as provided for in our Act. So the relevant factors are provided for in Section 32 of the Act, the factors that we look at. But maybe the starting point, like in any major analysis paper, is to define the relevant market, where we look at the product portfolio of the merging parties, and where we look at where there's going to be substitutability. We carry out our SNP test just for us to be able to define the relevant market like any other authority. And with specific factors that we look at, the trends in marketing concentration, which we come to looking at the market shares of the merging parties in comparison with other market players in the market, and we then do our HHIs and the CRR4 calculations. We also look at the barriers to entry in the market for us to determine whether the measure is going to enhance the existing barriers, or whether the existing barriers are sufficient, or whether entry is going to be sufficient, likely after the consummation of the measure. We also look at the level of import competition for us to see whether post-merger there's going to be import competition to usher competition to the merger, post-merger. Mostly we apply this to horizontal measures. We also look at the history of collusion in the market for us to see whether the number of players, how many number of players are there in the market, and for us to see whether if we are going to approve this measure, are we not going to enhance market coordination amongst the market players. We also look at the degree of countervailing power from the suppliers or from the customers of the merging parties. That is the ability to switch to other customers post the transaction, or to other suppliers post the transaction. We also look at whether the transaction is going to result in the removal of efficient competition, specifically for horizontal measures, whether the acquired parties was ushering ineffective competition to the acquirer. We also look at the factors regarding likelihood that the measure would result in acquisition of market power. This is mostly in terms of horizontal measures, where we look at market shares. We also look at the likelihood of whether any part to a measure is failing. So this is your famous failing firm defense, where we are going to weigh the gains of approving the measure just to have the market player continue being in existence, or to reject the transaction. And in most cases, where a part to a measure is failing, we mostly approve. And if we see that it has got an effect of lessening competition, then we approve with conditions that are aimed at addressing the identified competition concerns. So those are the factors that we look at when we are analyzing measures.
No, thank you for that. I don't know if Joshua, you have any questions, and we can move to the second theme.
Yeah, maybe again, 2 follow-up questions. Thanks, Calistar. You mentioned obviously market shares and HHIs. What's the CTC's approach to market shares? Are they, for example, if a proposed transaction post-merger will result in a market share of above 35%, is that something that the CTC will look at a bit more closely? And I suppose my question is the CTC receptive, or does it acknowledge that market shares are really just a screening tool as opposed to a hardline factor as to dominance or market power, or I suppose potential anti-competitive effects if it were to be approved?
Can I take a second part again, Josh? I didn't quite get the second part.
I suppose in sum, my question is, how definitive or how strict is the CTC towards particular market share thresholds? So if a merger results in a post-merger market share of, for example, 35%, is that something that the Commission will look at with more skepticism compared to a merger that's only got a post-market share of 25%, for example? Or even on the other extreme, if a merger results in a market share of 45%, is that something that the Commission will automatically flag as being anti-competitive? Or will the CTC still look into those other factors like countervailing bargaining power, barriers to entry, all of those issues?
Oh, okay. Thank you very much, Josh, for that question. Maybe let me start by saying that yes, the CTC considers the issue of market shares, and we do not have a particular threshold where we say that if then the merged entity is going to reach this threshold, like 35%, then we are going to prohibit the merger, or it then create a dominant firm. And also to point out, to say that the issue of market shares, we do not look at that in isolation. We consolidate with other indicators like the factors that I highlighted before. And so when we are looking at market shares, they are just a step for us to get to the concentration level. So the HHI or the CR4 is then the one that we use to determine whether the transaction is going to lead to concentrated markets or unconcentrated markets. And we also look at the movement in concentration. For example, if there's going to be less than 100% movement in HHI, then it means that the transaction is not going to substantially lessen competition just from the market concentration perspective. And if it's above 100% to 200 point movement, it implies that the transaction is going to may substantially lessen competition. So the issue of market shares, we don't look at them in isolation. We consolidate with other factors, and also we look at the movements in HHIs, especially for Zonda transactions.
Okay, that's very good to know. And I think also in keeping with international best practice, that market shares are just one, but a few factors that go into a merger assessment. Yes. And then as we spoke a bit about horizontal mergers, turning to vertical mergers where parties often put up efficiency arguments, or they'll broadly say this merger will result in a lot of efficiencies, it'll streamline distribution, economies of scale, for example. To what extent does the CTC require merging parties to provide evidence of those claimed efficiencies when submitting a merger to the CTC?
So currently in the current Competition Act, Josh, there's no provision requiring parties to submit any efficient gains as a result of a transaction. But we have looked at it, that factor also borrowing from international best practices. And we have also taken that into consideration to say, in cases where a transaction probably may lessen competition, we would approve it subject, of course, owing to the efficient benefits submitted by the parties and also verified by the Commission, however, subject to conditions that would address the identified Commission concerns. And on that point, I would also like to just alert you that in the current Commission Amendment Bill, we have provided for specific technological efficiency gains where parties to a merger can then submit their efficiencies to a from a merger, and then we also incorporate that in our analysis.
Oh, that's great to know. I think we'll maybe talk about the amendment bill towards the end when we go into trends and insights or forecasts for the next few months. I think going into my theme, reading through the Competition Act, it was quite interesting to see that the approach seems to be that competition and public interest appear to be intertwined in Zimbabwe. When we first engaged in preparing for this podcast, I thought it was a bit more distinct, similar to South Africa, where in South Africa, for example, the Competition Commission will run a competition assessment on one stream, then in parallel, it will run a public interest assessment in parallel, like I said. And then the public interest assessment has got a set of criteria. So employment for one, the ability of small and medium enterprises to compete, for example. Could you maybe explain the role of public interest in Zimbabwe's merger control regime and how that maybe differs from South Africa's approach to public interest?
Yeah, yes, Josh, you are right. Of course, in our merger control regime, both competition and public interest assessments are integral to our processes of merger regulation. And as you have indicated, the public interest provisions as provided for in the Act, they have got they are intertwined with the competition effects. Is just a unique provision compared to other competition authorities. But the difference that we have noted, as you have said, with the South African provisions, is that South African ones are more explicit than what is obtaining in the Commission's current Act. And in this regard, the Commission has made deliberate efforts to make public interest issues more explicit in the ongoing amendments that I've indicated. However, notwithstanding this, while the primary focus of merger regulation, as you know, remains prevention of anti-competitive outcomes resulting from mergers, public interest considerations have also influenced the Commission's final decision on mergers, particularly in sectors, in resource sectors, for example, like the mining sectors. However, like other Commission jurisdictions in the region, more weight is assigned to in the competition assessment with as compared to public interest considerations, which are then addressed through conditions. And we have not yet prohibited a merger based on public interest issues, but we only address identified public interest concerns through conditions. But as you have said, it's kind of a difficult situation that we are in at the moment in terms of the layout or of how public interest issues are provided for in the Act, because they are related to competition, and it may be very difficult sometimes to separate public interest issues from competition issues.
Yeah, it is interesting. It's also quite difficult to follow at times because it'll talk about the Commission doing a competition assessment and it has the factors that lead to an SLC or a substantial lessening of competition. And then it effectively says, if I understand it correctly, to say if there is an SLC that's got that SLC is effectively an adverse effect on public interest.
Yes.
That's how I understand the Act to read. Okay, so that's very interesting. And then you spoke about public interest being addressed through conditions. Could you maybe give us a bit more insight as to how often the CTC has imposed public interest related conditions and what those typically look to address? So for example, employment, is it trying to mitigate against retrenchment, or is it active conditions to increase headcount within a particular company or merged entity?
Yeah, so Josh, employment is one of the main public interest conditions that we have imposed recently on transactions where we feel that post-transaction there's likelihood that merging parties may decide to lay off workers, especially on transactions that involve foreign entities when they're going to bring their own people in our local companies, and we feel that there's going to be likelihood that employees are most likely going to be laid off. In those instances, we issue employment conditions mostly to junior employees. So our employment conditions will not apply to senior management because we understand that a new owner would want to have an entity steered by people who they trust and who they know. But for junior level employees, we have issued conditions that they will not be laid off for the next 2 years, 24 months. After which then the parties may decide what to do with them. We have also issued public interest conditions with regards to local procurement. We have handled cases mostly in the retail sector, for example, the OK and Food Lovers market transaction and the TM and Pick and Pay transaction, where we have issued a condition that the parties should continue to procure locally instead of importing their products. 85% of their procurement should be done locally. That's one of the public interest issues that we have issued, so that we're going to promote also the local industry. We've also issued conditions to do with industrial development. For example, in the lithium, of late, we have had an increase in numbers in the lithium mining sector, where we have had Chinese companies acquiring our own local lithium mines. And we have issued conditions where they are going to do mineral beneficiation, where we have imposed the conditions which led to them setting up processing plants of raw lithium, so that they can produce lithium ore to avoid exportation of raw lithium. And so these are some of the conditions that we have imposed, public interest conditions that we have imposed on recent measures.
Okay, very interesting. And then maybe turning more to competition-related conditions, you pointed me towards quite a recent decision regarding CBZ Holdings and ZB Financial Holdings. Could you maybe just give us a brief overview of what that merger was, the concerns raised there, and then also what the ultimate approach of the CT was, or decision of the CTC was, after assessing that merger?
Oh, thank you, Josh. So for the CBZ and ZB transaction, that transaction entailed the proposed acquisition of 51% shareholding in ZB Financial Holdings by CBZ, and the merger was happening at the holdings level, and a number of relevant markets were identified because these were big companies operating in different sectors. And so the merger was also analyzed in light of CBZ's recent acquisition of First Mutual Holdings Limited, and so the subsidiaries of FMHL were also assessed as part of CBZ. And the merger raised competition concerns in the banking market, where the transaction would lead to enhance the market concentration. And the merger also raised concerns in the reinsurance market, where ZB Re was viewed as an efficient competitor. And the merger would result in concentration risk, especially for insurance companies. The merger would also further concentrate the property and development market from a moderately concentrated to a highly concentrated market post-merger through merging Mashonaland Holdings and CBZ Holdings. It was also noted that in respect of the banking market, CBZ and ZB Bank, they served different markets, with ZB serving a niche market, which is the lower end to an SMEs, while CBZ was serving the middle to upper end market and also big corporates. So therefore, the merging the two brands was considered to limit consumer choice. And so in respect of the orders that we imposed, so we engaged the emerging parties with regards to the concerns that we had identified, and we discussed the proposed orders quite lengthy. And following the engagement, the Commission resolved to approve the measure only upon the parties submitting proof of divestiture from Mashona Holdings, ZBRE, Cell Insurance, and also subject to compliance with a number of conditions, which include maintenance of separate brands of CBZ and ZB. They're supposed to maintain them as separate brands even post-merger, maintenance of employment, like I've indicated before, and non-movement of portfolios from insurance companies or medical aid before notification to the Commission. However, the parties then informed the Commission that they had abandoned the measure, so it didn't go through.
Okay, very interesting. So, I mean, from your perspective, do you see the CTC as imposing more conditions more recently? Would you say that you're assessing transactions more closely, or is that just a particular transaction that gave rise to such concerns that warranted a divestiture?
I would say that the Commission has always been assessing a transaction thoroughly, but it's only that this time around, this transaction really involved big companies in Zimbabwe, those financial institutions that we regard as big. And we thought that there was going to be substantial lessening of competition, and I think that is why it has attracted so much attention. But like any other learning organization, Josh, you improve your skills as you go. And so I think the Commission now, from the training that we get and also from engaging other authorities, we are improving our skills in terms of measure assessment.
That's good to hear. Well, Carole, do you want to go to the next theme then?
Thank you, Josh, for that. So the next theme, Calistar, is the harmonization of regional competition regimes versus our Zimbabwean national regimes as it pertains to mergers. So what has been the CTC's experience with regards regional merger control in light of the fact that we're a member of COMESA?
Thank you, Carole, for that question. And so with regards to regional measure control, as being a member of the COMESA regional bloc and having the COMESA Competition Commission as the regional authority in COMESA, we have signed a memorandum of understanding between the Commission and COMESA Competition Commission to guide collaboration between the two regulatory authorities. And we have seen that the cross-border measures that have been increasing since the inception of the COMESA Competition Commission sometime in 2013. And where a regional measure may have an effect in the Zimbabwean market, Carole, the COMESA Competition Commission, they notify us of such a transaction, and we examine that measure in the normal way that we do, like our local transaction. We do our assessments and we give our input to COMESA for decision making. And in terms of collaboration, I would say that we collaborate very well with the COMESA Competition Commission, especially in those measures which may significantly lessen competition. And we have had several engagements between CTC and CCC. And we have also seen respect of the CTC's input in COMESA decision. I would draw you to if you know the Axonobio Kansai Plascon transaction, where the Commission recommended for a prohibition of that transaction in the Zimbabwean market, and I think that was done by COMESA. And also on the Heineken and Distel measure, if you would recall that we proposed for conditions, an approval with conditions, and the conditions that we proposed to COMESA Competition Commission, I'm able to say that all of them have been taken up by COMESA Competition Commission, even in their final decision. We have also benefited from that collaboration through capacity building workshops, where the COMESA Competition Commission would fund capacity building initiatives of our case handlers, the board members, the judiciary, and we have seen an improvement in case analysis and also decision-making owing to these capacity building workshops. We have also seen an increase in enforcement, like, for example, those transactions that ordinarily would not be notified to the Commission because they fall below thresholds. Now, because we are a COMESA member state, such transactions are now notified to the Commission for examination and also for an input to decision making. So I would say that we have seen an increase in enforcement following this regional major control regime.
Thank you for that, Calistar. So does the CTC often request that transactions notified to COMESA be referred to the CTC again for consideration under local law?
Yes, we do. We do request for referrals. I think it's also one of their provisions in their major control regulations, COMESA regulations, to say if a member state feels that a transaction may have a significant impact in the local jurisdiction, they are free to request for a referral so that we can assess it under, for example, in our case, under the Zimbabwean law. And ever since the inception of CCC in 2013, I'll say that to date, we have requested for referrals of 3 transactions, and we were granted 1. Of those 3, we were granted 1. On the other one, the Heineken and Distal Major, we missed on timelines. We were not aware of the 14-day period, and we requested for a referral after that period, and so we lost. And it was then decided at COMESA level. And on the Axon Bill, Kansai Plascon, we also requested for a referral because we felt that it had more impact in the Zimbabwean market. However, we were not granted because COMESA Conversion Commission said that thought that it was more appropriate or better positioned to assess the transaction because it had a huge impact in quite a number of COMESA member states. And so they said that they were best positioned to come up with an optimal decision that was not going to spill over into another jurisdiction. So again, we were not granted that referral.
Thank you for that. So let's say there's a multi-jurisdictional merger filing.
Yes.
Does the CTC communicate with other competition authorities who may be reviewing the same transaction in different jurisdictions?
Yes, Carol, we do. Actually, we've got a memorandum of understanding currently with the South African Competition Commission, and we are open to any other competition authority who may want us to have an MOU. But nevertheless, even if where we do not have MOUs, we have cooperated with quite a number of jurisdictions. We consult with other competition authorities in cases where a major filing is also done with other authorities. And we do this mostly in cases where a major may have more impact in another jurisdiction, right? For example, let's say a major is filed with Zimbabwe, is filed with Zambia, is filed with South Africa. Obviously, when we receive it, we will know that this transaction has more impact, probably on South Africa, on Zambia. We then consult with them just for us to have an indication of how they've analyzed the transaction and what is their preliminary assessment of the transaction, so that we do not deviate from that assessment, so that we are also in line with their assessment, just because we know that it has more impact with that other jurisdiction. And so to date, we have cooperated with South Africa, with Botswana, and with Zambia.
Wow, that's very informative. That's very informative, especially on the issue of our local CTC having memorandum of understanding, Josh, with other countries. I mean, that helps because at least it shows that there will be a smooth sailing of information share on a particular transaction, such that it doesn't stop completely because another jurisdiction isn't aware or don't know how to answer the specific questions and the impact of the transaction in that jurisdiction. So, Calistar, I'm going to move you to trends and foresights. As lawyers, we're always interested to see in knowing the future and trying to assess
where we can dip our hands in the near future and what's in it for us as the years go by. So is the CTC noting an increase in merger notification within a particular sector?
Oh, yes, Carol. So I'll just draw you to our statistics of 2024. In 2024, local to local transactions dominated the space at 43%. When I'm saying local to local, I'm saying transactions between companies which are domiciled in Zimbabwe. The measures largely involve domestic firms seeking to pool resources, also cutting costs and also increase market presence amid liquidity constraints. And 36% of the transactions were foreign to local parties and 21% were foreign to foreign, like Josh has previously indicated. Those foreign to foreign transactions, Josh, we have actually examined them. And in 2024, 21% of them were foreign to foreign transactions. In terms of which sector particularly dominated, the financial sector was at 22%, and also the manufacturing sector was at 22%. And the financial sector measures are largely dominated by the need to fund government projects like your road infrastructure development, for example, and also like the airport, the Robert Mugabe International Airport, which was recently renovated. We have seen measures coming through giving those reasons for funding huge capital projects. And for the manufacturing sector, the motives was really just to consolidate businesses and also to expand markets. So I would say we have seen increases in the financial sector and the manufacturing sector.
No, thank you for that. I think, Josh, over to you for the last two questions.
Yeah, thanks, Carole. Calistar, I think maybe coupled with the discussion we had on cross-border cooperation, obviously one risk and also an offense in terms of competition law is the prior implementation of a merger. How does the CTC go about trying to detect mergers that haven't been notified to it, which obviously crossed the mandatory thresholds? Are there particular tools that the Commission uses? Does it engage regularly with other authorities to see whether a merger should have been notified to it, but it wasn't? How do you go about doing that as an authority and on the ground?
Oh, thank you, Josh. So locally, I would say that we've got a memorandum of understanding with quite a number of regulators. And obviously, a transaction has to pass through some regulator or the other. And if it's going to skip CTC, maybe for ignorance purposes, but obviously they're going to go to another regulator. So we have signed a memorandum of understandings with ZSE, Zimbabwe Stock Exchange, with the Reserve Bank of Zimbabwe, and also other sector regulators for them to notify us. We notify each other of any developments in the market, and where they see that there's a measure that has not been notified to the Commission, they alert us. I'll give you an example of the recent CBZ and FMHO transaction where the parties sought to do a mandatory offer, which they do through the Zimbabwe Stock Exchange. And the parties that actually skipped us, and they sought for approval from the Zimbabwe Stock Exchange. And ZSE notified us to say, ZSE, are you aware of this transaction? And that's how we got to know of that transaction. So these MOUs, they really work. And in terms of our regional counterparts, like I've said before, we work closely with other authorities. We've got platforms where we share information. And so if they see any transaction, they alert us and we follow up on that. We also do our own proactive market surveillance, where the Commission will monitor public announcements, press releases to identify measures, and also depend on whistleblower alerts, especially during these stakeholder consultations where we often go and meet people. They alert us of any transactions that would have skipped the Commission's assessment.
Yeah, that's very interesting to know. And I think a lot of firms forget that regulators talk to each other, right? Like you
Yes,
say,
they do.
the CTC talking to the stock exchange or one of the other regulators in
Yeah,
Zimbabwe. So that's very interesting, and I think important to remember.
Yeah.
Just my last question, and we've touched on it earlier in the podcast, but we spoke about the competition amendment bill.
Yes.
I haven't seen it, so I'm quite interested to actually give it a read to see what's contemplated in terms of changes. Could you maybe give us a bit of insight as to what the amendment bill is seeking to achieve? Is it trying to do a complete overhaul of the existing Competition Act, similar to what the COMESA authority is doing now with its regulations, or is it pinpointing specific areas that it's trying to clarify or give the Commission a bit more powers in terms of? And then also, when do you anticipate that amendment bill being promulgated or becoming effective?
Okay. Thank you very much. So I'll begin by saying that it has been a very long journey for us to reach where we are now. And presently, the Competition Amendment Bill was presented before the Cabinet Committee on Legislation in that CCL, and CCL proposed some changes to the draft bill, and we worked on those proposed changes, and we are done. And the draft bill is now ready for the consideration of the CCL, for the second consideration of the CCL before it is then presented to the Parliament of Zimbabwe. In terms of the timelines, we are not really sure, but we are just hopeful that probably by the end of the year, it should have gone to the Parliament of Zimbabwe. We are just hopeful for that next year, by end of next year, we should be having an amended Competition Act before us. In terms of probably the quantum of the changes, they are quite substantial, I would say. They are quite substantial because the goal really is to give the Commission more powers in terms of both major regulation and redress of restrictive practices and cartels. Because as it stands now, in terms of penalties, the current act is not really quite punitive, except for measures, of course, where we can impose penalties of up to 10%. But as of the moment, in terms of restrictive practices, we can only fine up to level 14, and the level 14 is determined by the courts, which is even below, is it $1,000? And really, that is not punitive enough. So the goal of the current Competition Act is to make sure that it gives us more teeth to bite and to increase enforcement of the Commission. And maybe just to highlight the major aspects that the Competition Act, the new bill, is going to bring. So in the current act, you'd find out to say that the provisions with regards to measures, with regards to restrictive practices, are mixed throughout the Competition Act. And it may take you time to go through and to say, okay, this is restrictive practices, this is measures. And in the current bill, there's going to be a clear separation of restrictive practices, the processes, the penalties, and then measures, the definitions, the process, and the penalties. There's going to be a clear separation so that it is easier even for the user to be able to implement the act. And on major control, the bill also introduces a new concept that we call anticipatory compliance, where the Director General is now able to make decisions on failing firms, on applications from failing firms. As I've said before, it may take time for the Commission to complete its processes because the board currently makes the decisions. And in the new bill, now the director is able to give a temporary decision on transactions that involve failing firms. And on restrictive practices, also on major regulation, like I've said before, it now explicitly provides for public interest issues, just like any other authority in the region. And I guess it's going to be very easy for us now to implement the public interest regulations. And the bill also clearly provides for notifiability of increases in shareholding by merging parties. Now they constitute a measure in the new bill. And in terms of restrictive practices, the bill introduces punitive civil penalties for undertakings that engage in restrictive practices. There's also now a provision for leniency, like any other authority for undertakings that disclose collusive conduct. The bill also introduces powers for us to conduct market inquiries from which we can also make decisions. The current act only provides for powers to conduct investigations where there is a suspected infringement, but there's no powers for us just to initiate investigations through market inquiries. I would say in brief, Josh, those are the main areas where the proposed bill focuses on. Of course, there are more other institutional amendments, but I think in terms of the operation side, those are the main areas where the bill is going to bring in changes for the Commission.
Those are all, I think, very important changes, and I think probably a long time coming for the CTC, and I'm sure you're excited to start implementing and using, I suppose, the broader powers, and like you say, to have more teeth to go and do active enforcement and ensure companies are complying. So yeah, I'm excited to see what the CTC does in the immediate future. Sounds like there's a lot on the horizon. So this has been very insightful from my perspective. Thank you very much for your time, and to you as well, Carole. It's been very insightful. I'm sure we'll discuss further after this podcast.
Thank you very much, Josh. Thank you, Carole, for having me. It was also insightful on my end. Thank you.
All right.
Thank you so much.
Okay, all right.
Bye.
Bye.
Bye.